Okay, this meeting of the Public Service Commission is in session. Just a couple of housekeeping things, and then I'm going to turn the chair over to Commissioner Pinocci to preside over the oral arguments that are before us today. But before we do that, I wanted to acknowledge the fact that this is Constitution Day, a day we set aside to celebrate clearly one of the most meaningful and important documents frankly, ever to have been crafted, and we want to make sure that we, in fact, take a moment to celebrate that. In keeping with that, we will, in a moment, begin with what will be a new custom at the Commission, and we'll open the formal proceedings with the Pledge of Allegiance. Also want to announce that Commissioner Koopman, after a brief break at the conclusion of oral arguments, will be presenting remarks with regard to the unique importance of the Constitution. So I encourage all of you to be here for that as well. So with that, I would ask all of you to stand and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Commissioner Pinocci.
Thank you, Chairman Johnson. This hearing is called to order. All persons speaking should use the microphone. This hearing is being transcribed by Court Reporter Holly Fox. We will be on the record. If the proceeding goes off the record, always put it back on the record before receiving more testimony. Look at that. Good afternoon. For the record, the time is 1:32. The date is September 17th, 2019. The place is the Bollinger Room of the Montana Public Service Commission in Helena, Montana. This is a scheduled oral argument in docket 2018-010-068, the Commission's investigation into Northern Telephone Cooperative's use of federal universal service funds. I am Public Service Commissioner Randy Pinocci, officer for this hearing. With me today is Vice Chairman Lake, Commissioner Koopman, Tony O'Donnell, Staff Attorney Zach Rogala will be advising the Commission, and of course Chairman Johnson's to my left. The purpose of today's oral argument is to consider Northern's motion for reconsideration of the Commission's order to compel responses, order number 7638B. Northern requests the Commission to reconsider various paragraphs in the order regarding the Commission's jurisdiction and various paragraphs regarding the ordered procedures for this investigation. Northern will be provided 30 minutes for its argument and approximately 30 minutes scheduled for the Commissioner and Commission staff questions. Recess will occur when needed during the oral arguments. The public will be given an opportunity to comment at the beginning and conclusion of the proceeding today. Are there any informal questions before we begin? At this time, I'd like to ask, is there any public comment? The public will now begin the opportunity to comment. Okay, you wish to comment orally, please come forward and speak. It doesn't look like we have any. I was sure expecting some. Northern Telephone oral arguments, Monica Trinell. On behalf of Northern Telephone Cooperative, you may proceed.
Thank you, Mr. Chairman Pinocci, Commissioners Johnson, O'Donnell, Lake, Koopman. Good afternoon. Thank you for making this time. Monica Trinell on behalf of Northern Telephone Cooperative. And just sort of somewhat of a housekeeping matter, but I think it's important and for purposes of the record, this did start out as an in-docket 2018 10.18, and it has now been modified under the commission's cut over to a new electronic system. And it's important, though, for our purposes and to acknowledge that this was never opened as a contested case proceeding. And so I don't know what the status of the commission's numbering system is, but this was started as an in-docket and not ever considered a contested case proceeding. And I think that's an important piece of information for the record, and just want to, make sure the commissioners are in mind of that. So as we begin, I thought it might be useful for us to all orient ourselves in place and time here and look at where we are. So we're talking about Northern Telephone Cooperative. It's very small. It's up on the northern border of Montana. It has 6 exchanges. It serves 3,000 miles and about 1,000 access lines. So we're talking about one of the smallest, most rural cooperatives in the entire country and in Montana.
3,000 square miles?
Yes. Well,
You said 3,000 miles.
yeah, that's what they told me, so we can get clarifying information. So, and here's a picture of the ripper and cutting in fiber. So you can see in this picture how rural the area is, and how remote it is, and how far they have to go to actually serve a customer. So Northern is a cooperative. It's organized under Title 35 of the Montana Cooperative Statutes. And it is, this is a statute this is the old statute going back to the early part of the 20th century. Cooperatives are exempt from the jurisdiction of the Public Service Commission. And that's a global exemption, and the commission doesn't have any inroads into that total exemption. Going forward, in 1997, after the passage of the 96 Telecommunications Act, there was the Universal Service Fund set up, and in order to get that going and to designate these rural cooperatives as eligible to receive the universal service money, state commissions that didn't otherwise have jurisdiction were given a very narrow ability to designate these carriers as eligible for this money. So because the exemption for co-ops is global, this commission had no ability even to designate these carriers as eligible for this money. So the legislature had to create an express ability for this commission to do that. And they passed this law saying this commission is authorized to designate these carriers as eligible for this money. So this was an express grant of authority, not jurisdiction, for this commission to put these carriers into this eligible fund. And it's important in subsection 2 what the Montana legislature did in adopting the federal statute and scheme. They made it mandatory. So the commission didn't have discretion in doing this. It shall designate the carriers as eligible for this money. So this is a 1997 statute that was adopted that gives this commission not jurisdiction. We have the global exemption, but this ability to designate them as eligible for this money. And when we're talking about these cooperative state and federal schemes, these are really important nuances. And it's not a nuance, it's clear legislative language. The exceptions, the exemptions from jurisdiction were expressly preserved. So not only was the authority to designate very narrow in what it granted this commission the ability to do, it was not a jurisdictional grant, it was an authorization to designate, very narrow. In addition to that very narrow authorization, which is mandatory, the legislature expressly and explicitly preserved the exemption from regulation for co-ops. 693823. Nothing in Part 8 affects the exemption in Title 35. Co-ops are exempt from regulation, period. Then, and this was in 1985, that was not changed in the 97 statute. And then also in 1997, in addition to passing the authorization of designation, the legislature explicitly said this authorization to designate does not grant any jurisdiction to the commission except as expressly set forth. So there it is. It's very clear this commission only has the ability, the authority to designate. It has no jurisdictional grant at all under clear Montana law. So I thought we would start out with that framework and how that plays out then. So the commission simply doesn't have jurisdiction over cooperatives. And I'm happy to answer any questions as we move along. But what we're asking the commission to do now is to dismiss this entire docket for lack of jurisdiction, because the commission simply does not have the jurisdiction to issue the kind of investigation it did here, and to acknowledge the express Montana law that limits that. So the other parts of this that are troubling are that in this case, the commission issued an order to show cause to Northern, which is it's a small cooperative, 11 employees, 4 days after receiving an email from one of its members about complaints or concerns that member had. So the whole framework of Title 35 for cooperatives is that members have an express way to complain to the cooperatives and to seek a remedy. And this member, Maggie Nutter, did that. So in the spring of 2018, she had a statement of issues that she submitted to Northern, and then she tried to petition to have changes made. The Northern Cooperative held a special meeting, which Ms. Nutter got enough signatures on her petition to have a special meeting. That was held in November, and the changes that Ms. Nutter, as a member of the co-op, was requesting were voted down by the members. So she went through the cooperative process and didn't get what she wanted. And so she came here to see if she could shake something loose with you. And what's important in that is to compare a side-by-side of what Maggie Nutter was asking of Northern with what this commission's order to show cause did. And if you look over here on the left-hand side, these were the statements of concerns that Ms. Nutter presented to her board, the Northern Board of Trustees. She said she was asking for access to Northern's check register. She was expressing concerns about the trustees' conflicts and how the board members were behaving. She submitted this email to the commission on September 21st, and 4 days later, this commission issued an order to show cause directing Northern to produce information about its board members' compensation and about self-dealing and affiliate transactions. That had nothing to do with Northern's use of its universal service funds. And Northern had no opportunity to respond to that. There was no notice to Northern. There was no ability for it to respond. The commission assumed that all of these concerns were well-founded and deserved some kind of an investigation. And that's not how the process works. A disgruntled member of a co-op can't simply call up a single commissioner, write an email, and get an order to show cause for a full investigation. Think about a comparison. What if a ratepayer for Northwestern, a fully regulated utility, called you, one of you, and said, gosh, I'm really concerned about how Northwestern's spending some of its money. They bought this equipment, they bought that truck, and they should have bought a GMC and not this. Would you issue an order to show cause 4 days later? That would not happen. And that's what happened here over a cooperative that's not regulated. That's a very troubling process that happened. Then the staff memo that went out in February that was advising this commission about, the order that would come out, suggested to the commission that the concerns of Ms. Nutter were about potential abuse of federal funds. Here on the right-hand side, we have that email that Ms. Nutter wrote to the commission in full. I know the PSC does not directly have oversight of telecommunications cooperatives. I am very concerned about some issues directly related to the Board of Trustees. I would like to discuss this issue with you. There's nothing in there about potential abuse. And how is that a leaping off point to a show cause order? How does that happen? That process on Constitution Day was an absolute violation of the constitutional rights that Northern has to due process and notice. Then we get to the order that we are asking you to reconsider. Both of the orders, 7638A, which was issued in June, and then B, which was reissued in August, say that the member contacted the commission to raise concerns about potentially illegal behavior. That is not true. The email does not say potentially illegal behavior. And where this commission went with an email from Ms. Nutter is simply too far. We're asking you to withdraw this entire docket and this investigation. This is not the place for this kind of a process to unfold. This commission has overstepped the bounds of the role that it plays in designating ETCs. That's all it does. It doesn't investigate them, it doesn't have jurisdiction over them, and it certainly doesn't regulate them, which was the suggestion of how far this commission could go in the staff memo that was given to you. So I'm happy to answer any questions. Our request is that you withdraw this entire docket on the basis that you don't have jurisdiction to proceed with the investigation. But I'm happy to answer any questions, Mr. Chairman.
Is there any questions from commission staff? Would you like to make a point first, Chairman Johnson?
Questions?
Okay.
Are we going to go to council first, or how are we doing this?
First on the list is, are there any questions from commission staff?
Thank you, Chairman Pinocci. Welcome, Ms. Trinnell. I just have a few clarifying questions. In your oral argument, you noted that Northern is requesting the commission dismiss this docket for lack of jurisdiction. And that wasn't included in the initial Northern motion and brief for reconsideration. So should I try and blend the reconsideration motion request and today's request so that the motion's request was reverse its finding has jurisdiction over Northern, compel Northern, and reverse the finding that Northern must produce information. Further, the commission should hold this action in abeyance pending a decision from the district court. In our declaratory ruling action, should we read these together, or should we just take Northern's request as a motion to dismiss?
Thank you. And just to clarify, Mr. Chairman and Commissioners, so our written motion for reconsideration did request that this docket be held in abeyance. So the annual recertification process was in play, and Northern's very lifeline is on the line here. And so in an effort to protect itself and its business and its customers, we filed a petition for a declaratory ruling in district court for a determination on the question of jurisdiction. And that was filed in June. That's pending, and we are proceeding with that question. We think the right answer for the commission right now is to withdraw this docket completely because it doesn't have jurisdiction. That is an amendment to the written motion for reconsideration in which our request was that the commission hold this in abeyance pending the outcome of the district court decision. But we think the right answer is that the commission dismiss it outright for lack of jurisdiction. And alternatively, we would ask that the commission hold it in abeyance. Does that clarify your question?
And let me just restate. So primarily, Northern is requesting we dismiss the docket. And if the commission decides not to dismiss the docket, then alternatively, Northern requests that we stay the decision and remove the jurisdictional finding and the requirement to compel Northern to produce further information.
Yes.
Okay. That does clarify. Thank you. Mr. Nell, no further questions. Chairman Pinocci.
Now I'd like to turn questions over to the commissioners. Commissioner Koopman, would you like to go first?
Thank you, Mr. Chairman. Yeah, and I'll try to be brief. I guess just as a practical matter, and ultimately, yes, the law and due process and the Constitution prevail. But as a practical matter, and there seems to be a certain amount of conflict in law, depending on what areas of code you look at, and the federal code, and then also our ARMS, our regulations, administrative rules. But as a practical matter, I do believe. Well, this is a question. Do you believe it's reasonable to assume, for the commission to assume, Ms. Trinnell, that the public expects the same body that initially certifies a carrier for ultimately millions of dollars in public funds through the Universal Service Program, to be able to monitor over time for the purpose of recertification if they are using those funds consistent with federal law and with the public interest, and if not, then why should we be involved in the process at all if we have no authority to protect the public interest, or who does, who would investigate, who would protect the public interest in these matters?
Mr. Chairman, Commissioner Koopman. So let me address I think that there are two parts to your question, so I would like to address those in turn. So I think the first part of your question is the public's expectation of this commission. And then I think the second part of it is what's in the public interest. So with respect to the first part of your question, how do you address the public's expectation of oversight and monitoring of these funds? I think the answer to that is really simple and very clear. This commission is bound by the law. This commission does not make the law, it doesn't write the law, it executes it. And the law is clear. This commission does not have jurisdiction over cooperatives, period. So in terms of,
Excuse me, can I ask for a clarification? By you say the law, you meaning state law or federal law?
both.
Thank you.
So the public's expectation of how, what the oversight process is, the answer, I think, for the commission is we are following the law in terms of designating these carriers. There is an oversight process, and that's handled through the FCC and USAC. And we set that out in our papers. There's a quality assurance program that they have to follow, and they do. Northern has been subjected to that process. They've submitted their reports, and they've been in compliance with it. So it's not as if there is no oversight. It's just not this commission's job to do it. It's USAC, and it's the FCC's job. And it happens there, and they do it. So in terms of expectation of how this cooperative federal-state scheme unfolds, you know that this happens in healthcare, environmental, all kinds of education. We have these interactions of federal and state laws across the board. With this particular law, what happens is you have been given this very narrow ability to designate these carriers as eligible for this money, and the federal process is to oversee it, monitor, and investigate it, and they do. So that's part one, and I'm happy to follow up on anything. But to go to part two, I think the public interest piece of it, what's important to understand is that 69.3 sub 3 is the only part of the statute that talks about the public interest, and that only comes into play when you're looking at a second ETC in the same study area. So we have Northern up here with 6 exchanges. If a second carrier were to come in there and apply for this money, then you get to look at that public interest prong. Not until then. Before then, your obligation under subsection 2 is mandatory. You shall designate the first ETC, which is Northern, as eligible for this money. Does that answer your question?
Sure, it does. Appreciate that, your thoroughness. And I guess following up on that, is it fair to say then that the position of Northern would be that the regulation, if you will, of their activities and things that are alleged to be, although apparently not originally by Ms. Nutter, to be questionable and possibly illegal, self-dealing and so on and so forth, that occurs on the ground level within the co-op itself and the board members that are chosen, that are elected by the members, and obviously there's always the opportunity for going to court, but that's where these sorts of things should be investigated and regulated, if you will, is on the co-op level.
Yes, Mr. Chairman, Commissioner Koopman, yes. The short answer is yes. The longer answer is that there are sort of two pieces of this that you're looking at right now. And where the commission went astray here is to really get involved heavily in the operational side of a co-op. That is absolutely governed by Title 35 and the members of the co-op. Those are operational, day-to-day business decisions. Do we purchase a ripper or do we rent one? Is it better to have one in our stock so we can send it out on demand, or is it better to pull one out when we can? Those are day-to-day business decisions that the co-op makes and are completely addressed and remedied within Title 35, as you implied, I think, with your question.
Okay, and yeah, because frankly, the commission has been somewhat frustrated, and we've had an end docket on this some time in the past, of how do we ensure that good stewardship of these federal dollars, And of course, we're talking not just about co-ops, but primarily by the non-co-ops that that are regulated by us. And and it's at this point we don't really have much oversight, maybe any at all, in the process of recertification, and that's a challenge. But from your knowledge, how is this handled in other states? I'm just wondering if there's any kind of a precedent we're setting here. How do commissions in other states dealing with universal service funds deal with the co-ops? Do you know?
Mr. Chairman, Commissioner Koopman, I didn't research what other states are doing specifically, but I do want to answer, I think, the first point that you made. And I think this is important for the Commission to keep in mind, and something to be proud of how our rural companies serve Montana. These places have broadband. That wouldn't be the case if it weren't for these rural telcos doing their job. That's something that is, that is a success story. It's a positive story, and I think it's something to keep in mind that as you go forward, this isn't woe is us. Things are all going, falling apart here. Things are running really well, and our most rural citizens in Montana have high-speed internet because of the rural telephone companies, including the co-ops. And that would not be the case if these entities hadn't looked at this and gotten into it starting in the 1940s and 50s.
I'm curious, for the record, do you know approximately what percentage of the total annual revenues of Northern, I believe they get about $210,000 a month right now, ongoing in universal service funds? Do you know what percentage of their total annual revenues that is, and if that was withdrawn, if it would threaten their viability as a business?
I can tell you that Northern and none of these rural co-ops would exist without the universal service fund, without the high cost support.
Well, I think I may have just one other question. Let me just quickly look through my notes here. I'm sure other commissioners have questions, so I don't want to monopolize the microphone here. Yeah, I'll pass on that. Yeah, I guess this is a challenge because we want to do our job, and obviously we must do our job consistent with the law, and this is largely a legal question, although it's also, as I say, a practical question of what we do to guarantee as best we can in the public interest good stewardship, good use of these funds. These federal funds, and I guess, do you feel that in any sense, and I realize the 1997 law that was bill that was passed by the legislature seems to indicate otherwise, but is not the authority to designate an ETC to certify them, isn't that a form of regulation right there, even if it appears that we're not to regulate in other ways? Isn't that still a commission authority, if you will, a regulation in form?
Mr. Chairman, Commissioner Koopman, I think I understand what you're asking, and it's sort of, the question is, and this is why I wanted to go through these statutes in such detail, is the question is, doesn't the designation authority that we have contain some kind of implicit obligation to oversee how that money's being spent? And that's how the commission ended up where it is today, because that's been the analysis to date. And the answer is no. The answer is no. That is not embedded in here. And what's really important for the commission to remember, and having sat in legislative seats, you know this to be true. The legislature was not unclear. It was very clear and very, very directive. The authority that this commission has is only designation authority. And in addition to that, the legislature was very clear and retained the explicit exemption of oversight by this commission and said nothing in that grant of authority to designate overrides the exemption of jurisdiction. So you're not operating in a vacuum where you're trying to figure out, is there some implicit authority? You have very clear legal mandate here. You do not have jurisdiction over these co-ops, period. And nothing in the designation statute gave it to you.
Thank you, Ms. Trinnell. Mr. Chairman.
Commissioner Lake, would you have any questions?
Thank you, Mr. Chairman. Good afternoon, Mr. Trinnell. Glad to see you again. Following on that same line of comments, the FCC seemed to be very specific in their requirements to the ETC recipients. Am I okay up to this point?
Sure.
Okay. Well, they designate us to if a state commission were to take over that designation. But part of that same statement, and correct me if I'm wrong, but part of that same statement is that we shall determine the qualification if they are qualified to receive them. But if we do not have any authority that would allow us to do that, then how can we, in good faith, make a designation if we can't see whether or not the current funds are going to the places that they've been designated for?
Mr. Chairman, Commissioner Lake, I want to try to understand the question that's being asked, and I think what you're asking is, isn't there some kind of a threshold, a qualification that this commission is required to, oversee? And the answer again is, so we go back to the statute. So the commission is authorized to designate these carriers as eligible. It applies to all carriers notwithstanding the exemption from further regulation. So you shall designate that carrier that meets the requirements as an eligible carrier. There's no, this commission doesn't have a quality oversight process for these carriers. The FCC and the USAC monitor and oversee how the money is being spent. But this designation authority, there's not sort of a, you have to meet a certain threshold and then you get over it into the door of the eligible funds. And I think that's where we're kind of falling off the rails here, is the purpose of this statute was because this Universal Service Fund was created by the 96 Act. Mm-hmm. And the federal statute, when it was being passed, they understood that many of the carriers who would be eligible and receiving this money are exempt from regulation. So there had to be a mechanism by which these carriers could be designated as eligible for this money. And that's this process that unfolded and was passed in these statutes. There's not sort of this minimum, you have to have 20 employees, you have to be, 5'8", and you have to, there aren't these qualifications that you have to jump through ahead of time. It was a necessary statutory grant of authority to designate them in light of the fact that they are totally exempt from regulation by the state commission. Does that answer your question?
Well, it's hitting on the outside edges of it. But part of the designation of eligible communication carriers by the FCC says that we shall designate a common carrier that meets the requirements. Now, and that's where the question comes in, is how, if we have the responsibility of approving, doesn't it also carry the responsibility of determining whether or not the requirements are met?
Well, so then you have to say, what are those requirements, right? And so it's that they're using the money as intended, and that's the USAC's job to make sure that happens, and that they're advertising the services. So that's what the USAC does.
Okay. Now, let me ask you then, should we, as the Public Service Commission of Montana, even be in this process? Shouldn't we turn this back to the FCC and let them not only verify the use of the funds, but handle the approval and the designation as a qualified carrier?
If that's what the commission wanted to do, then it needs to look at this statute right here, 693840, because right now the law of Montana is that this commission is mandated to do this. So you don't have the ability to throw your hands up and say, no, so we don't want, you guys want to do it, you do it. You have a legal mandate from the legislature of the state of Montana to designate these carriers as eligible for this money.
Okay. And I appreciate the comment, but if it comes with the limitation of being able to function as a authorizing agency, but we do not have the mechanism to do that, then should we even give any designations, since we can't see whether or not they're following all the requirements that's put in front of us from the FCC?
So that's the, Mr. Chairman, Commissioner Lake, that's the legislative mandate, is that you are required to designate them as eligible for this money. That's the mandate. And if the discussion that the questions that you're raising are, concerns that the commission has, then the fix is a legislative fix, that you would need to have the legislature grant you broader oversight of these co-ops. You don't have that in today's law.
Well, basically we have a conflict between federal law, which says that they can designate a state agency to handle the approval process and the designation process. But if state law, then where is, and I'm wandering a little bit, let me back up. Since there is a conflict, can the commission then just deny any approvals and designation as an ETC carrier?
Mr. Chairman, Commissioner Lake. So first of all, I would take issue with the predicate assumption in the question that there's a conflict.
Okay.
So the federal law, and this is the cooperative federal state law scheme. The federal law says that state commissions who don't otherwise have jurisdiction, can designate these as eligible, and then the state law says, okay, you don't have jurisdiction, so you can designate them. So I don't think that there's a conflict there. That's, this is how the process was set up and intended to work, to give the commission the ability to designate them. And then the oversight happens from the USAC of how the funds are spent. And that's where it should happen. I mean, these are the experts. They deal with that all the time. They understand how the funds are dispersed, how they go out. These are complex accounting schemes, and they have the ability to do it at that level. And that's not something that is, it's not eviscerating the role of the state commission. it's handling it where it's appropriately and well handled.
But as an agency, if we are not given that same reporting information, is there any reason for us to be in the mix, since all we're doing then is just giving the okay when the application is given? I mean, there's not a decision to it.
And Mr. Chairman, Commissioner Lake, so there's not that's a question that the commission doesn't have before it, and doesn't have the discretion to say yes or no to. The commission cannot say there's no reason for us to do that because you have 840 sub 2. The designation is mandatory, and you have to follow the law.
Gets back to my previous point, Mr. Chairman. Excuse me for going by you, I appreciate that. And Ms. Tronell, is there any reason for us to be in the mix when we do not have any way of verifying that the numbers that are reported, or we don't even get to see them? All we're doing is getting a filing that says we've done everything we're supposed to do, and please sign on and let us go. We don't. I mean, it's frustrating for me as a commissioner to be put in a position of not being able to verify, if you will, the spending of the funds, the USB funds, without having and expecting us to sign on, without having any way of verifying that anything on it is correct. Since the FCC has got all that coming into their office, of which we are not privy to. So,
Mr. Chairman, Commissioner Lake, let me just say this, that the reason for this commission to continue the annual certification process is, because you're mandated to do so. And this commission is required to follow the law. That's the reason.
okay, Mr. Chairman, and I'm not going to belabor this. It's frustrating for me, but has a question for, and I will give it to you both in one, so we don't have to back it up. Has Northern or any other ETC designated provider in the state of Montana ever been investigated by the FCC that you know of?
Mr. Chairman, we submitted as exhibits to our motion for reconsideration letters from USAC and showing that they have been investigated. They have had to show their accounting reports, and they are in compliance with the law. And these are very thorough investigations. They are by expert accountants, and you have a small staff. USAC does this all the time. They're pros. That's what they do. They know how to follow the money. They know how it's dispersed. And we did show you in our exhibits that Northern has been subjected to that process. They've followed it. They've abided by it. And USAC has signed off on their use of this money as being appropriate.
Okay. And Mr. Chairman, Mr. Nell, finally, has Northern ever been required to do additional work to meet the requirements that are required or that are placed on them?
Mr. Chairman, Commissioner Lake, the answer is no. I don't know what that process would look like, but no, there's not been any additional
All right.
process.
Thank you very much.
Thank you, Chairman Lake. Chairman Johnson, do you have any questions?
Thank you, Mr. Chairman. Ms. Tronell, first, a question that probably I would know if I had gone through How to Be a Lawyer 101, but you draw a distinction between authority and jurisdiction, and I'm not clear how we can have no jurisdiction but still be able to exercise any kind of authority. Help me understand the distinction there.
Mr. Chairman, Commissioner Johnson, I think it's a good question, and I think that was part of why I wanted to have this explicit statutory language in front of you as we walk through this, because I think the question seems to be, and I think part of how we got to this moment in time where we're looking at a reconsideration is that we have morphed these questions that the commission has, morphed this, and the statute is clear. It's not ambiguous. And so if you look at this right here, the first sentence of 840 sub 1, the commission is authorized to designate. So that's what you have by virtue of the Montana legislature, right? The authority to designate. And then if you look at the exemptions that were retained, nothing in this part affects the exemption from regulation, and then the jurisdictional preservation. This section does not grant any jurisdiction. So I would answer your question by pointing to these specific statutory pieces and language and say the authority to designate was just that the federal part of this cooperative federal-state scheme says states may designate these carriers as eligible for this money. And then the Montana legislature said, okay, look, we've got these co-ops. They're completely exempt from the state's the commission's jurisdiction. So how do we handle this? We can't give the commission jurisdiction over them, but we need to put them into this designation piece. And so they said, we'll give you the authority to designate. And they preserved the jurisdictional piece of it. So I would just point you to those statutes and that specific language. And I think the legislature meant what they said.
Mr. Chairman, Ms. Trinnell, I'm still not in it, and we won't belabor it, but I'm still not sure how we can conceivably exercise authority anywhere without jurisdiction to do so. But that's fine. Let me move on here and make sure. It is your contention that the role of this commission in terms of designating as eligible in ETC, that the extent of our role there is to say, yep, USAC didn't say they didn't meet the requirements, therefore we designate them as eligible. Is that the extent of our ability to analyze the petition for eligibility that comes before us?
No, and the commission has a process that it's put into place where you require a sworn affidavit from these carriers that they are using the money as it's intended. That has consequences. They are swearing to you under oath, and so you've set that process in place, and so you do have recourse under that sworn attestation of how it's being used.
Mr. Chairman, Ms. Trinnell, understand that, but if we have a sworn affidavit before us and with no authority or jurisdiction to verify what is being sworn to, we still are little more than a rubber stamp here. And so I'm not sure how we meet our obligation if we say we can simply take at face value what is represented to us in that sworn affidavit.
Mr. Chairman, Commissioner Johnson, I think I understand that the heart of the matter really is sort of what power does the commission have here, and not wanting to be a rubber stamp for these annual certifications, right? So in the interstices of that, where do you come down and how do you operate? And so to go back a little bit to the question, because I think it's a legitimate one, the point that you raise is, how do we have no jurisdiction and yet this authority to designate? So I guess I would answer that by saying you have power granted to you by the legislature to designate these carriers. So, if you use the umbrella term of just jurisdiction to say we have jurisdiction to, designate them, if, that's, I think we're getting into verbiage at that point. But that doesn't give you jurisdiction over the operations, over rate regulation, right? But I don't want to interrupt but I think that the question that you're really asking and you're trying to get to the heart of is, well, are we just a pass-through agency? And I think that you have to look at the statutory mandate and the scheme that is set up here, the cooperative federal-state scheme. And in this role, that is what the commission does. It is designating these carriers as eligible for this money and recertifying them on an annual basis for it. And the process is that the carriers have to swear that they're using it as intended, and then the federal part of it is that they have the ability to oversee it and monitor it. And if this commission is, of the view that it should have a more expansive role, then I think the place to have that happen is to go to the legislature and request that. The way the law is right now, the commission doesn't have that expanded authority that you're concerned about.
Mr. Chairman, Ms. Trinnell, we then do not have the authority to verify the validity of the sworn statement that comes to us from the ETC.
So that's a little bit of a different question, Mr. Chairman, Commissioner Johnson. So the question that you asked is to verify the validity of the sworn statement. So in terms of, is a sworn statement that comes in, I'm certifying that this money is being used as intended, I think, then that is handed over to the feds, right? And so if the USAC were to investigate them and find that there was something amiss there, then that sworn statement has other consequences that can be followed up on.
Okay, but it would be, excuse me, Mr. Chairman, Ms. Trinnell, it would be USAC that would have to make that determination of that sworn statement having been falsified.
Well, so USAC would undertake an investigation of how the money's being spent, right? And so if representation is being made under oath that it's being spent as intended, and then there's an investigation and a determination, well, no, actually it wasn't spent as intended, then there is a problem, which is, I think, where you're going with this line of questions, and who follows up there. So, if you have a false statement, I don't know that USAC would follow up on prosecution of a false statement, but that's really a pretty far afield of where we are in terms of, is the money spent the way it's intended to be spent?
Mr. Chairman, I'll try and wind this up, Ms. Trinnell, but if we are certifying as eligible an ETC based on the sworn statement that comes to us, we either simply take that at face value with no analysis whatsoever as to whether or not it represents the true facts, or we try and look into the underlying facts of that sworn statement to determine whether or not it's valid. But you're suggesting we don't have the ability to do that. So if we don't have the ability to determine the truth of the underlying facts that support the sworn statement that comes to us that we're supposed to use to designate eligibility according to the requirements, and that's in it brings me back to what the heck's the point. If our mandate here is simply to say, okay, thanks for handing us that piece of paper that says, I swear this is true and we should get the money, it's a pretty pointless exercise.
Mr. Chairman, Commissioner Johnson, I want to speak to what I think the frustration is here. And this is not a chicken and egg exercise. The commission's role is important in terms of certifying them, and that's the way the federal statute created this ability for the states to designate these carriers as eligible. And look, I mean, go back to this first picture here that we have. We have a huge state. we have so much of our state would not be served if this commission had not designated these carriers as eligible for this money. So this isn't a chicken and egg question, because the question that you're asking is, what happens if they're not using the money correctly? And that is investigated by USAC. So what this commission can't do is get an affidavit, a sworn statement from these rural carriers and go, well, gosh, I never really did like that, so-and-so who signed this, and I think he's lying, and so, we're not going to certify him. That's not how it happens. There is an ongoing oversight process that happens and is initiated by USAC. They do performance quality, reviews. They look at how this money is being spent. So you're not stuck in this sort of endless loop where you have no authority or no ability to look at this. Your role is important, and we would not have broadband to huge portions of this state were it not for this commission's designation of these carriers as eligible for this money.
Unless, Mr. Chairman, we simply had a situation where the FCC and USAC made the designation of eligible applicants. Any rate, I appreciate your time and your being here, Ms. Trinnell, and I'm not going to take up any more of Commission time, Mr. Chairman. Thank you.
Thank you, Chairman Johnson. Commissioner Tony O'Donnell, do you have some questions?
Thank you. I wanted to make a statement first that I am quite certain that no one in the employee of this commission, elected, hired staff, in any way, shape, or form, wants any jurisdiction whatever over any telephone cooperative, electric cooperative, anything that we don't have authority over right now. In fact, I think there's quite a bit of sentiment on the commission that we didn't have authority over some of the areas we have authority over now. Okay, but having said that, let me ask you a question. The letter in question, the complaint letter, referred to if I'm quoting correctly off of what you had up there, potential abuse of federal funds. Now, you mentioned before that without federal funds, these cooperatives would probably go under, which was my own observation also. So it would seem that pretty much any abuse of funds could probabilistically, I think that's the right word, include federal funds in there. Had the letter to Commissioner Kavula stated possible misuse of members' funds, then that would only tangentially imply a possible misuse of federal funds. However, it was specifically stated possible misuse of federal funds. I don't think it's your contention that at that point we should have just said, sorry, we can't deal with this. Is that your belief, that we have no role whatever to even give this any recognition whatever?
Mr. Chairman, Commissioner O'Donnell, so I think there are a couple of parts to your question. So let's go back to the initial setup here, and I put this up on the screen here. So the initial email here that came in is here on the right-hand side, and what Ms. Nutter wrote in an email was, I'm very concerned about some issues related to the Board of Trustees. So your question is, had she just put some additional language in there, would that allay the concerns about how this docket started out?
No, if she had left off the word federal before funds, that's what I'm talking about.
Well, that's not in here. So
potential abuse of federal funds received through the Federal Communications Commission high-cost program. If the reference to federal was absent from that and anything beyond received, just potential abuse of funds, I agree with you, it would be absolutely outside of our jurisdiction. The fact that the federal was in there, and we are required to certify if somebody is eligible, and therefore whether they're misusing funds, because if they're misusing it, misusing the funds, they're not eligible. I think under pervasive public law, wouldn't you agree? If somebody misuses it, they're not eligible for any more?
So, Mr. Chairman and Commissioner O'Donnell, this is an important point.
It is.
Because this gets to the heart of one of the pieces, and our argument to you is there was no due process here. So let's look at what we have. And I hope the mic can still pick me up as I walk over here. This is the email that you got right here. This does not have anything to do with federal funds. It says, I have a concern about the Board of Trustees. All the commission knows at this point, they could be going out dancing on Wednesday nights. They might be walking on the wrong side of the road. You have no idea what the commission has in front of it when it opened an investigation was a concern. That's it. So here's our concern with what happened here is this docket became an order to show cause without any notice, no ability to intervene, no ability from Northern to say, whoa, what's going on here? We have a staff memo that takes that. I'm concerned about the Board of Trustees to a potential abuse of federal funds. That's from your staff. That is not from Ms. Nutter. And that is part of our concern. And that is part of why we're here today.
When she said in there, FCC funds, that F stands for federal. That raises the issue completely.
Well, what she's saying there, Mr. Chairman and Commissioner O'Donnell, is she's saying, I know the PSC doesn't oversee these, but I understand that you certify them. That's all she's saying. There isn't anything of substance there for the commission to launch.
You're going.
full-scale-
Okay, wait a minute. I see the path you're going down. That is not responsive to the question that I posed. I'm not talking about the procedure. I'm talking about when somebody says federal funds potentially are being misused, then what action should we have taken? Should we have just ignored it completely, as if somebody had said members' funds are being misspent, which we would just ignore it completely. We have no interest in being involved in the affairs of these things, except insofar as it involves federal funds. And in a previous footnote, quoting FCC regulations, it does point out that states have the explicit responsibility to ensure that federal funds are not being misspent. You spent the first half of your presentation talking about the authority under state law. No problem with that whatsoever. But we're not, when you involve in federal funds, then it goes well beyond any state authority, any state jurisdiction. We now are under the regulation of the Federal Communications Commission. And we are required, as I understand that footnote, we are required to follow up on this, okay? We take it very, very seriously. None of us want to be involved in this thing. We wish this whole thing would never have started, gone away, somebody else would handle it, whatever. But when somebody comes to us and lays us at our steps and says, an organization you have certified is eligible for funds, we say maybe misusing those funds. I think every member of this commission here realizes, looks at that and says, yeah, seems to me if we're involved in this somehow, we're involved in this part of it too, and we have an obligation, a legal obligation. That's why I asked the clarification under law. Was it state law or federal? You said both. But in your original statement, you meant no mention whatever of federal law, only state law. Nobody's questioning that. Nobody wants any authority over them. Only as it has to do with the potential misuse of federal funds, period.
Mr. Chairman, Commissioner O'Donnell, I'm not sure if there's a question or if you want me to speak directly to something, but I think, I think it kind of circles back to the concern that I hear you expressing, that where do they go if you get a complaint from a member?
Do we have authority? Do we have the direction by the FCC to investigate these matters? You said we don't have any state authority. Do we have federal mandate to do such?
No.
Okay, Mr. Rogala, I turn it back to you. The footnote came from your pen saying that, as I recall, the word was required to follow up on this.
Chairman Pinocci, Commissioner O'Donnell, I stand by the briefing that we submitted to the commission earlier in our staff memo in February, which we subsequently turned into the initial order to compel responses in June of this year, which we subsequently retracted and reissued a second order to compel responses in August of this year. Where I come down on this is that we have state authority to investigate the allegations of high-cost abuse or abuse of high-cost funds under MCA 69-3-840, and that we have concurrent direction and authority from the FCC's regulations to thoroughly investigate claims of high-cost funds abuse and also thoroughly investigate annual designation and maintenance of ETC authority. However, I completely understand Northern's arguments that reading MCA 69-3-840 subsections 1 and 2 together provide a strong counter argument that the commission is just limited to designating a telecommunications carrier that meets the requirements of 47 U.S.C. 214E1. How I come down on this is I think the law's 70% in our favor, 60% in our favor, 40% in Northern's, 30% in Northern's. It doesn't matter. I think this is a difficult legal question, but I think we have jurisdiction to continue this investigation, and Northern clearly disagrees, and that's where we are.
Thank you, Mr. Regala. Yeah, and see, nobody here is trying to say that Northern is guilty of anything. Nothing at all. Certainly, if somebody came in and accused another person of a capital crime, it's worthy of investigation. I think, as an attorney, you take that seriously. Somebody regards something, and that's our position. Say we don't want to be involved in this thing. Okay, and maybe in terms of procedure, maybe the thing was to immediately remand it to the feds. I think as an individual person, I'd much rather have somebody locally investigate something than the feds do it, because they might come in and say, well, pending the investigation, you don't get any more money. Okay, we'll hold it back for a while. Well, that would be really burdensome to any entity, in particular a cooperative like this, that is dependent, as you pointed out, on these funds. So I thought maybe it was a good thing to handle it locally here, just amicably. Just give us the information. If it's right, it's right. If it's wrong, it's wrong. Whatever. Okay. So the procedure that you're talking about, I understand. There's some. You seem to have some good grounds for that. We have good grounds, as Mr. Regala is pointing out. But I think what the feeling is here is that because federal funds are involved and we're the ones who are that somebody is eligible, that potential misuse of funds renders upon the determination of whether or not somebody is eligible. So that's my position, Mr. Chairman. Oh, you may respond to yours. I'm sorry.
Mr. Chairman, Commissioner O'Donnell, I would just point out that I think one of the concerns, the procedural concerns that this docket presented for the commission was that there was no advocacy staff, separate from the advisory staff. And so, there was these sort of unfolding, moving targets of investigation that seemed to be ever expanding. And to the point, to your point and your question of, wasn't there just sort of a way to make this go away easily? And that was really the commission's concern was, we wanted to try to make it, and I hear what you're saying there, and I think Northern does as well, but I think that what the commission really needs to keep in mind here is this isn't about personal preferences, about who we would rather deal with. The question is about following the law. And the legal framework here is clear, and the mandates are clear, and they're not ambiguous. And so our personal preferences don't get to override that.
It's just that you keep on saying the law. You are completely, totally ignoring what Mr. Rosgala has said about FCC requirements. That is the law also. Federal law seems in this case to transcend the authority granted by the state, okay? In no way, by following the dictates, the requirements of the FCC, have we intended or I think done anything to override the authority, the integrity, the individuality, the non-regulatoriness of telephone co-ops in Montana. This is strictly following the money, following the trail of federal funds. What the co-op does with its own members' funds, that is up to the members to decide. Clearly, okay? The membership there, while not having access to all of the books and records and knowing exactly how much money was spent from whatever fund, okay, as far as you know, when the federal funds come in, are they kept in a sequestered account or are they mingled with all the other money? So that really, when a check is written, nobody knows exactly what funds it came from. Is that correct?
The accounting the mechanisms are very complex, and
Yeah. So-
there are lots of
Right.
details
So
to that.
individual members aren't going to be able to tell whether or not. So it takes a professional staff who is trained on following financial trails to be able to determine the nature of funds that were misspent or spent. Okay.
Which is the point of having the USAC be the overseeing body here, because that is what they do. That is where the expertise resides.
So you're saying you are denying that the FCC requires us to do some investigation of potential misuse of funds?
Absolutely. And the
Okay.
concern really, this is important, Commissioner O'Donnell, because the concern here was that the staff was, going from advocacy to advisory, and we were trying to figure out, how do we get to a resolution here? And so that was a significant part of how this docket unfolded and the problems that were created. You're pointing to the advocacy of staff, and who were we countering with, and how is the commission both the arbiter and the prosecutor in this case? That's a problem.
Thank you, Commissioner O'Donnell. Monica, this is my district that this cooperative is in. District 1 is probably in the Stone Age on communication compared to the other 4 districts in Montana. So to tell you to get future ETC money to this cooperative is important to me and this district. Wouldn't you agree with that?
Chairman Pinocci, I guess if you're asking me to agree with what's important to you, obviously I respect what
Let me
you're...
restate that. Do you think District 1 is in need of money to get the communications to the level Districts 2, 3, and 4 are, and 5 in Montana?
Well, certainly we are talking about large swaths of rural area, and District 1 is a huge area for sure. And
That's what I was trying to say.
yeah, but to the extent that you have communities that are, I mean, you've got El Zeta and you have Haver. I mean, so it depends on which data points you end up comparing. But I think your question is, are these monies important to your district? Absolutely, certainly. Couldn't agree with you more.
The next $2 million coming to Northern Cooperative in the future, ETC money, do you believe that's important that they receive that?
It's their lifeblood.
So my question to you is, if this Public Service Commission has the vote to either approve the money or not approve the ETC money, do you agree with that?
The commission has the ability to designate them as an ETC and then to certify them on an annual basis. Yes, that's what the commission has the ability to do.
Would you say that it's a possibility, after reading this in the paper, dated September 12, 2018, Shelby Promoter, Nutter explains, one of Nutter's top concerns is that Northern Telephone funds may be used inappropriately with a large portion of Northern Telephone Cooperative's income received from federal communications. Do you think that's a possibility, that this would raise a concern to this commission where they would not approve that $2 million?
Chairman Pinocci, I think where you're going with this is really, it does go to the heart of the process piece of this. You're citing a newspaper article, and this was a letter that Ms. Nutter submitted to Northern's Board of Trustees. And following that article, there was a response from the board. There was a special meeting that was called by Northern, the co-op, of its members, and that was held in November. That had a significant turnout, and, you know, special meetings they're special. They don't happen, on a scheduled basis. So there was a big turnout at that November meeting, and the members voted on this. Ms. Nutter got enough signatures to have a special meeting called, and that happened. And at that special meeting, those concerns were presented to the members, and they voted on it. So those concerns were handled within the framework of the cooperative process, which is how that's supposed to work. And so that process happened, it unfolded, and Ms. Nutter didn't convince the members of the co-op to vote her onto the board, which is what she sought to have happen. And that's the cooperative process that's in play in Montana and works. So those concerns were handled at the cooperative level. They were not dismissed.
Well, here's a news break for you. Before you get those $2 million, this commission's going to have to approve it. I'm pretty sure I got some phone calls that said, if there's some wrongdoing, Pinocci, please tell me you're going to look into it. And I said, yes, I will. Now, wouldn't you expect the other commissioners to feel very comfortable whether wrongdoing has happened before we approve the next $2 million? How would you answer that?
Well, the place for that investigation to happen is at the federal level through USAC. So, if there's some appropriate oversight and monitoring that needs to take place, there's a place for that to happen that's set up, and that process should unfold the way it's set up to do. That's the way it works.
Let me ask this question. Let's say that unfolds, and this commission is still not comfortable because they haven't had their chance to be convinced that no wrongdoings happen. We have the ability to make sure the $2 million doesn't go there. So don't you believe it's important that this commission has access to ask questions and get comfortable before that money's approved?
Commissioner Chairman Pinocci, I think that if this commission considers there to be a necessary additional role for it to play with respect to how these funds are spent and monitored, then that's a legislative change that it needs to get. Under the way the law is currently set up, it does not have the authority to do that.
Do you think that I could tell my constituents that voted me into office that I should approve the $2 million without being convinced there is no wrongdoing? Do you think that is something I can tell my constituents?
Chairman Pinocci, I think to the concern of how you represent this process, the commission has followed the law. There is an oversight and investigation process that's available. And, if concerns are raised, then they can be taken to USAC. That investigation can unfold. And if the commission is still uncomfortable with the results of that, or feels like it hasn't been thorough enough, or there's more that needs to be done, then that's something that the commission can take up, or on an individual basis, you can take up with USAC. But that's the process. It's not that there's nothing. It's not that there's no process at all. So you're not telling your constituents, yeah, we're just, there's no oversight or monitoring. That process is in place, and there's a way for it to happen, and that's where this needs to proceed. Because those are the accountants who understand, and I think it was Commissioner O'Donnell raised the point of these are very complex accounting schemes and where the money is dispersed and how it's spent and what it's intended for, what you're doing with it. They're complicated questions, and USAC has the professionals that can address that and investigate it in a meaningful way. So,
This position for the Public Service Commission has staff, attorneys that, consult with the commissioners to support a vote or a decision. My constituents are going to expect me to go with those taxpayer dollars that protect the public's interest, my attorneys within this office. And I'm going to have to ask them, are we comfortable to vote for the additional $2 million? Or should we be looking at the records? Should we be looking at bank accounts? Should we be looking at statements? If they advise me that we need to do more or not vote for the $2 million, I'm going to hurt my district that badly needs that money. I have other cooperatives calling me, board members saying, we hope that the actions here don't affect our ETC money in our county. To the right, to the left, Randy, we need you to take this really serious. So I tell them I'm going to work with the commissioners and I'm going to be listening to the staff. And if they need information, why would you not give it to them so I can move forward and put this behind us? Give them everything they need. If you don't, it looks like you're hiding something. Would you agree?
Commissioner Pinocci, there are a lot of questions in that. So, I'm familiar with the obligations of the staff attorneys. I've been one here. So, and to to your question of how does this process unfold and how do we get it right? I think it's important that the commission understand it, and that's why we're here today. Until today, Northern hasn't had a chance to be heard in this docket at all. And so I think it's very important that, if your constituents come to you and ask that, isn't a fair response to that? Well, if somebody accuses you of some wrongdoing, don't you have the right to some kind of a due process notice and a right to be heard? I mean, being accused of something isn't a conviction. It's not a determination that you're guilty. And so that's one of the biggest concerns here, is that the commission just went from I'm concerned about the Board of Trustees to an order to show cause. That's a big leap. And due process means something. And I'm certain that your constituents would expect the commission to abide by that.
Well, I'm hoping that we're able to get all the facts we need so that we can continue getting FTC money to all the cooperatives that need it. But a real responsibility is if there is misuse, I think a commissioner has to take a look at not approving that money. So I have no more questions.
Mr. Chairman, if I may, just because I think the point has been raised by Commissioner O'Donnell and several of the other commissioners about nobody really wanted to be at this point in time. I mean, this isn't where, your preferred stance is, right? Nobody wanted a showdown here. And one of the things that I think is important that the commissioners understand is that Northern did produce significant amount of information in response to the first order to show cause. And we were discussing with staff the ability to make this go away. And we had discussed an on-site audit and what that meant. And that was, to our knowledge, never really presented to the commission in a way that was meaningful, because an on-site audit and just packing up information and sending it to the commission are really different things. And, the commission staff does on-site audits. It's done them before. They're possible. And there was a way to make this go away. We offered that to the commission. We didn't want to be here any more than you did. And just, dropping a few little reports into an envelope and sending it off to the commission, that wasn't an option. And once information is in the commission's hands, it's considered public. So there were all kinds of issues that weren't respectfully handled for Northern. And so that process, was one that led to the point of going to this place where we are today.
I have a question for Mr. Rogala. Are you waiting for any information that you'd like to have from Northern Telephone Cooperative? If they provided you everything you need.
Chairman Pinocci, we are waiting on substantial pieces of information to inform our investigation. We don't think that the information provided in the initial response by Northern in January or December of this last year provides us the information we need to conduct our investigation.
Thank you, Mr. Rogala. My advice, and I'm asking you please, because I think my district, to represent them, needs all the help they need, is to give this commission what they need, because we are the decision maker whether this FTC money is approved. And for you to go down the road that, we don't have authority, or, we can't make this decision or that decision, is really a waste of time, because we make the decision whether this FTC money is going to continue. So based on that, please get us what we need.
And Commissioner Pinocci, I will just say, because I think this is important for you to know and to consider, that that's information that we had discussed producing earlier with appropriate sideboards and protections. And I'm certain that you understand why that's important. That, it was not reasonable to simply just send you all of the, the books and the confidential information from Northern. And we asked that it looked like this was just an ever-expanding investigation. We said, we'll give you this. Well, we want this and plus this, this, and this. Okay, well, we want some sideboards. Well, no, just send it all to us. That's not appropriate or reasonable. And I'm sure you understand that as well. That, producing information to the commission was something Northern was willing to do early on in a spirit of good faith compromise with appropriate sideboards. And I don't think that was an unreasonable thing. And that, it didn't happen. The investigation just kept growing.
Well, I have no more questions. The public will now be given an opportunity to comment. Is there anyone here that would like to make a public comment? Well, for the record, the time is 3:04, and we'll end today's proceeding. Thank you.
Thank you, Mr. Chairman.
Mr. Chairman, we'll reconvene for Commissioner Koopman's remarks in what? Commissioner Koopman, 10 minutes?